Good morning. My name is Tom Hardiman. I'm a judge on the Court of Appeals for the Third Circuit with chambers in Pittsburgh. It's a great pleasure for me to be here with you this morning with these luminaries of the corporate law world. Not being an expert or even remotely an expert in corporate law, I'm looking forward to hearing what they have to say. Should be a great learning experience for all of us. I'm going to introduce each speaker before they make their opening statement, if you will. Each speaker will talk for between 6 to 8 minutes before we move into more of a debate slash question and answer format. Our first speaker this morning is Professor Stephen Bainbridge. He's the William D. Warren Professor of Law at UCLA, where he teaches business associations, advanced corporation law, and a seminar on corporate governance. Professor Bainbridge received his JD from UVA in 1985, and he's been on the faculty at UCLA since 1997. Professor Bainbridge has written several books on corporate law and over 75 law review articles. In 2008, he was named one of the 100 most influential people in the field of corporate governance by Directorship magazine. He's also a prolific blogger at professorbainbridge.com, and if you visit that website, which I encourage you to do, it's quite interesting, you will learn why Professor Bainbridge is not sporting a tie this morning. Please welcome Professor Bainbridge.
Thank you very much. My job this morning is to tee things up for my fellow panelists to address the merits of what's been going on. So I will try to the best of my ability to be neutral or fair and balanced, as a certain network puts it. For the last 200 years in the United States, the corporations have been subject to a regime of state chartering. The combination of the internal affairs doctrine, which says that corporate governance issues are governed by the law of the state of incorporation, and certain Supreme Court decisions under the Dormant Commerce Clause holding that states generally may not exclude foreign corporations from doing business within the state, has had the effect of creating a sort of common market of incorporations. If I want to do business in Illinois, I'm not obliged to incorporate in Illinois. I can look around the country and find state laws that suit my needs best. And so, for example, I could incorporate in Delaware. Living in California, I am perpetually bombarded on radio with ads about how I can become a millionaire by incorporating my California business in Nevada. Not entirely sure why Nevada incorporation inevitably leads to millionaire status, but apparently it does. Now, this process then has created what's known as competitive federalism. States can raise franchise taxes and other fees from the corporations that they charter, and so there is a competition among the states to attract the most corporations possible so as to maximize these revenues. Now, scholars and regulators disagree about what the impact of that has been. Many regard this as a so-called race to the bottom, in which states compete by offering corporate managers laws that permit managers to enrich themselves at the expense of shareholders. Other scholars reject the race to the bottom hypothesis, claiming that in fact the incentives of managers are to incorporate in states where the law will be attractive to investors so as to minimize the cost of capital. Still, other scholars and regulators believe that there's no race at all that states really don't compete very much. And I know that my fellow panelists will have views on that issue. Of course, as we all know, the runaway winner, whether it's been a race to the bottom, a race to the top, or a leisurely walk, has been Delaware. Delaware, of course, has famously attracted majorities or at least substantial pluralities of the Fortune 500, the Wilshire 5000, and so on. And Delaware, of course, is the leading state for public corporations. And so historically, we've sort of thought about Delaware versus the other 49 states. But today, Delaware faces a new competitor, the federal government. Although the federal government, or Congress, I should say, on a number of occasions, particularly during the New Deal era, considered creating a federal law of corporations, that had never happened, and corporate governance remained almost entirely a matter of state law, really until 2002, when the Sarbanes-Oxley Act intruded federal regulation into a large number of state areas, such as audit committees, rules governing a whole variety of internal controls, and the like. When the Obama administration took office and began addressing the financial crisis of 2008, the role of the federal government exploded in regulating corporate governance. Now, thus far, the regulations that the Obama administration and Congress have authorized are primarily limited to financial institutions and other companies where there's been federal bailouts. But there is a substantial possibility that we will see permanent federal intrusion into a number of areas of corporate governance. The Senator Schumer has the so-called Shareholder Rights Act pending. The Senator Dodd's omnibus financial regulation bill has a number of corporate governance provisions. Congressman Frank, his financial regulation legislation is likely to have a number of corporate governance provisions in it. Well, what are the issues then that are in play these days? Probably the most prominent, and probably the one that's the most likely to end up becoming a permanent feature of the American landscape, is say-on-pay, the proposed non-advisory shareholder vote on executive compensation. Other issues that almost certainly are going to happen are some form of shareholder access, the ability of shareholders to nominate directors. As you know, the SEC is currently in a rulemaking proceeding considering some form of shareholder access. A number of bills have included provisions mandating at the federal level majority voting for board of directors, provisions for separating the chairman of the board and CEO position by creating a non-executive chairman. Were in a lot of these bills, it was in the Dodd bill, although the Dodd bill has since taken it out, eliminating classified boards of directors, imposing risk management committees, and of course compensation. Most of these bills have some form of compensation regulation in them. The bottom line then is that we are in an environment in which the old sort of horizontal competition between states is being displaced by a sort of vertical competition between the federal government and Delaware. And the question, I guess, that we want to talk about today is, as the federal government seems to become more and more willing to intrude on state corporate governance in this way, are we likely to get better, more efficient, however you want to phrase it, corporate governance rules, or are we likely to get rules that are less efficient, that provide less freedom for companies to order their affairs as they see best, and so on. I'm not going to weigh in on that aspect of it yet, at least, because I know that my fellow panelists will address that issue for you. And so with that, I'll turn it back to the moderator.